Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the orders of the Green Tribunal cancelling environment clearances for not following the prescribed public consultation process. We will also talk about the issues relating to the National Green Tribunal. To discuss the issue, I have with me Mr. R. Venkatramani, Senior Advocate, and Mr. Kailash Vasudev, Senior Advocate. Now for the headlines. The Green Tribunal cancels environment clearance of Jindal Steel and Power and Chettinad Power Corporation. The companies had violated the prescribed process of public consultation process. And we will also talk about how the tribunal lacks power of contempt and suo motu. Environmental clearances of major projects like Jindal Steel and Power in Chhattisgarh and Chettinad Power Corporation in Tamil Nadu were cancelled by the National Green Tribunal recently. The order clearly states that the two companies did not follow the most important procedure, the public consultation. Let's look at the process of public consultation and the impact on companies that violate it.
Majority of the 27 orders of the National Green Tribunal cancelling the environment clearances are on the ground that the process of public consultation was not followed as prescribed by the Environmental Ministry's 2006 notification. The National Green Tribunal has also accused the government of not implementing the environmental norms specified by them. According to the tribunal, the process of public hearing is a classic example of violation of the rules and the principles of natural justice.
The conduct of the public hearing is disturbance. The proceedings are disrupted and there is slogan shouting by both parties against each other. And mostly it is seen that they are politically motivated. So there is involvement of political parties in that. And therefore the problem that is coming is that the environmental issues, the various environmental aspects, they are not brought forward.
Police presence there, you don't get enough time to the people to express their view. There is violence in it. Sometimes it is so far that people may not be able to reach it. Secondly, the entire problem is also compounded by the fact that you do not give them the required information to participate.
Let us look at the public hearing norms prescribed for environmental clearance that are violated by the private enterprises. The Union Ministry of Environment and Forests has laid down standards to conduct public hearing process in its Environment Impact Assessment EIA notification 2006. According to this notification, every environment clearance has to go through 4 stages: screening, scoping, public consultation and appraisal. The public consultation process will have to be conducted by the district magistrate or his or her representative not below the rank of an additional district magistrate, assisted by the State Pollution Control Board SPCB or the Union Territory Pollution Control Committee UTPCC. As per the norms, public consultation process should be conducted at the project site or in its close proximity, and the consultation must involve all the affected localites and the environmental protection representatives. Authorities must take a written response from the participants and affected local persons after the discussion. Only then the Environmental Impact Assessment Report EIAR will be prepared. After following this procedure, the appraisal committee may consider the project for environmental clearance.
There are 3 stages. One can divide it into 3 stages. One is pre-public hearing. The second is actual public hearing, and third is post-public hearing. So there are defined activities which are to be done during those processes. The public hearing process starts with project proponent approaching State Pollution Control Board and requesting that a public hearing should be organized. And then the State Pollution Control Board decides the date, time and venue of the public hearing.
The National Green Tribunal order was made after considering whether the public consultation was prescribed by the Environment Impact Assessment Notification 2006 or not. The tribunal also considered whether the written response filed by the complaints were addressed or not. It found violations on both the fronts, and so it cancelled the environment clearances granted to these projects. National Green Tribunal's judgments are widely appreciated by environmental activists, but the recent incident took place with activist Ramesh Agarwal, where he was grievously hurt by some other parties, is creating cause of concerns in these matters. Raj Kamal, Rajya Sabha TV.
Public consultation is a process where the government arranges a public hearing and takes the point of view of the impacted population. Through this, the citizens get a chance to approve or disapprove of the venture. My question to you, sir, is public hearing, public consultation, designed in the statutes or by the prescribed by the Environment Ministry. Implementation problems were highlighted, as you understood. No one politically motivated, environmental issues are not taken care of, and then so many other management issues. In a situation like this, does it really make sense to prescribe something like a public hearing?
I think merely because we have deviated from the very important principle of consultation and we're not able to conform to higher standards and we not address the question of structuring the public consultation process, should we completely abandon it?
And the awareness level is down, and the entire process, the way it is conducted by the government, is it doable?
That's what I'm saying. Therefore, you don't look at people as a mass to be gathered there and then call it a public hearing.
Exactly.
So it's not a people to be gathered there. You have a structured process, information sharing in advance, a kind of a literacy on public consultation. Post-hearing, what happens? Information is not shared. So a report is given. And the report is sometimes a very esoteric kind of basis. So even the best of NGOs who are well educated on engineering, scientific and disciplines are seldom able to really contribute on behalf of the people as to what is wrong with a particular decision reached. So it all becomes Greek and Latin to even lawyers who handle these matters. Judges, I don't think, are in a better position.
Get it, sir. Sir, the question to you is, let's say there is a process known as public hearing. And if the people agree to degradation of environment, is there a way to stop the process?
The answer to that is yes. Environment protection has become the order of the day. If it is the order of the day, you have statutory protections which are given in the matter of government policy. You can take a decision to maintain a green area, forest notifications, wildlife national park notifications, national river notifications. So you have a whole gamut of areas where you can notify areas to be protected in the national interests or in the community interests. So to say that there is a power to notify an area for a specific environment purpose, yes, there is. The problem arises when the executive takes upon itself the authority under the various acts to change the land uses. When the land use changes, the impacts on it become very serious. You may have a 5-acre plot which you want to convert into a housing colony in a belt which is 500 hectares of agricultural use. Moment you have a 5-acre conversion by an executive power under a master plan or a state development plan, that 500 hectares gets affected because that 5-acre is going to break the continuity of the natural flows.
Yeah.
Hence, you must have a system where executive decisions have to be in conformity with the statutory directions issued for the protection of forests, rivers, roads, lands. You cannot permit a breakaway from the system just because an executive officer wants it, because then they're going to be partying to private interests at the cost of national interest.
I'll ask Mr. Venkatramani quickly, sir. Development, the way India is seeing it right now, and there is this push to get the people into the system, get systems like public consultation up and about, just get it over with and start the development work, whether it be setting up of a big project or whatever, in whichever area. If you have the people who are inhabitants of that area with you, then you've got a success. That is what it, development versus environmental issues. Is this the way to resolve it?
Well, this is an old debate. We can
Mechanism of public consultation.
Therefore, the question is, let's not pose the two things are irreconcilable. We started with that. The Narmada issue started on that foundation. people as opposed to development. Fundamentally wrong. So let's not look at it from that point of view at all. If there has to be a holistic, equality-based, egalitarian society, it's not development which probably is going to bring, egalitarian principles into practice. Something else perhaps. The world is still trying to, look forward and discover such as those economic principles or economic practices which can reconcile people's needs on the basis of justice and equality, and at the same time a quality of life where basic needs are met. So while we're talking about and debating all this, unfortunately, from
Public
a point...
consultation as
I'm coming to that.
as
Therefore,
a
we
way
think
to achieve it.
Therefore, we think public consultation is only a kind of a secondary importance, where issues, we talked about it earlier. Well, people do not matter because they do not know what they really want to say. People do not matter because they do not know what they can actually, talk about, discuss on these issues. So why do we have a public consultation? So it is chimerical. It is a farcical exercise. So from the point of those who, practice economic issues on a certain level, who promote industry, development, and all those cliches.
Profiteering.
That's right. So they said this, well, people do not matter.
Here I'll give you an example. You have rivers which are sold to industry today. It doesn't make sense. In Chhattisgarh, I believe they are now permitting rivers and the water from the rivers to be commercially managed by industry. What is the impact?
We'll come to it, sir. It's time for us to head into a break. When we come back, we will tell you about some of the issues which have compromised the effectiveness of the Green Tribunal. Welcome back. The National Green Tribunal has not been empowered as envisaged, due to which its effectiveness is compromised. The tribunal does not have powers of contempt, nor does it have the powers to take up issues suo motu. The National Green Tribunal was formed by Parliament and was given the role of protecting the environment.
The National Human Rights Commission, Debts Recovery Tribunal, the Central Administrative Tribunal, and other tribunals are empowered to act suo motu, which allows them to take action against any violator without waiting for a complaint. The powers of contempt to ensure that no one takes the tribunal lightly. Both these judicial powers are not available to the National Green Tribunal, which is headed by a sitting judge.
Any case of suo motu so far, and after the Act provides a challenge to order, so there has to be some kind of order.
Let's look at the principal act that set up the tribunal. According to the National Green Tribunal law, the tribunal will have jurisdiction over all civil cases relating to environmental concerns. The tribunal will hear matters of disputes between parties and can pass an order. The tribunal has the power to provide compensation or relief to victims of pollution or any environmental damage. It can also provide reimbursement in case of a damage of property. Any person aggrieved by the decision of the tribunal can appeal to the Supreme Court within 90 days of the tribunal's order. Failure to comply with the tribunal's order will be punishable with imprisonment of up to 3 years and fine up to 25 crores or both.
There has been judgments of the High Court that there must be some evidence to show that you have gone through the minutes of the public hearing. What actually happens is there is a cut-paste model that is followed, copy and paste. You copy from one, put it on. The public raised these concerns. These were duly noted by the Expert Appraisal Committee. And based on this, we are there. How these concerns have been raised, what are you going, what is the view of the Ministry of Environment on each and every concern, we find no mention of that.
The National Green Tribunal was created in 2010 for effective clearances of cases relating to environment protection and conservation. The law was made to synchronize our laws with the decision taken in the United Nations Convention on Human Environment in 1972. Majority of the industrial projects coming up in forest areas are headed by high-class business community in this country. Hence, there are no one to oppose these kind of projects that are coming into the forest areas. If NGT is given suo motu power, these powers can be used to clear and to stop the environmental violations happening in these forest areas. Raj Kamal, Rajya Sabha TV.
Being deprived of suo motu powers ensures that the tribunal can't act even if it is aware of the worst happening in environment violation till a complaint is made to it. Is that true, sir? Is that true?
That is correct, because the act in itself is a truncated act. it gives judicial powers to a limited extent without defining what exactly a settlement is or what a dispute is. You may have a dispute under the schedules, that is under the Water Act or the Air Pollution Act or the Environment Act. Only those can be referred to the tribunal. But to do it suo moto is a much wider power. Please understand, the National Green Tribunal Act was set up in retaliation to what the Supreme Court was doing. From 1990 onwards, the Supreme Court became the sole guardian of forests, of the environment at large, whether it is the Ganga Action Plan or the Yamuna Action Plan or the river cleanings or the mangrove protections or the Sundarbans. All these issues are before the Supreme Court. It set up the monitoring committees in 1990s, the EPCA, for example, then the monitoring committee under retired officers of the court, as also in consultation with the Government of India for retired forest members of the ministries. When these things came up, three things happened. All applications made to the Supreme Court for the purposes of forest clearances were referred to the monitoring committee.
And the ministry lost its relevance.
The ministry became of no consequence because the regulation was by the court. It was in the matter of granting permissions,
Yes.
conservation of forests, collection of funds for reforestation. In 2009, the Supreme Court had collected 11,000 crores by way of the Campa fund.
I remember that case, sir.
I'm coming to it.
Yeah.
The Campa fund became a source of great, should I say, showdown between the Supreme Court and the government, which said that money belongs to government, please give it back. Supreme Court says, no, we will use it for an appropriate purpose. Now it has been directed that 11,000 crores will be dispersed to the states, and the states in turn will follow the NREA-GA principle for employing workmen. That's a different chapter. But what I'm saying is this: the Green Tribunal should have been given some tooth to look after issues of
Are you
serious
trying
impact.
to say that this tribunal was brought in retaliation to
I
counter
say so.
the Supreme Court
I say
activity,
so.
and it was not given powers deliberately
Yes, that is my
so
view.
that the environmental issues remain an issue but are not acted upon?
Correct. Because the environmental issues are framed under the acts. Who does it? The executive. Your members of this tribunal are 20 members of the executive who are brought in. See the constitution. The experts are people who come in at the discretion of the chairman as also of the courts. But largely it is those 20 who are executive members, that is the officers of the government, who will be regulating the affairs of the tribunal. They will also be sitting in government before joining the tribunal. So you are carrying from Caesar to Caesar's wife. It is not making sense.
Mr. Venkatramani, another point was contempt, powers of contempt. Why have a sitting judge at the head of the tribunal when the two basic powers that he enjoys?
I'm sorry, I'm interrupting you here. The sitting judges of the tribunal have resigned, 3 of them. 3 judges who were appointed to the tribunal resigned because they were unable to carry out their functions. Keep
Right.
that at the back of your mind.
Yes. 3, you have a judge, and a judge is a judge. If these two powers are deprived, taken away from him, is there anything else that is left for a judge?
I think just to continue the same point of view which Kailash made, the authority of the Supreme Court and the way it handled the environmental issues, regardless of what I may call the process adopted through the centrally empowered committee, so on and so forth, the authority of the court was felt in a variety of ways. Now, we want to transfer the whole authority to a different institution. The institution must enjoy the same status. If it doesn't enjoy the same status, it doesn't get it by merely an appointment of a retired Supreme Court judge. It's an individual. It doesn't matter at all. But the institution lacks all that grandeur and authority and the power of a Supreme Court. Point number 1. Therefore, we will not say whether it's deliberate or not, but whatever reasons, you don't add on to the power of the institution by not giving it a content power, by not adding certain what called special machineries by which you can enforce your orders and decisions.
Threat is not there.
That's one thing. But should we have a threat perception? We are talking of people's
Okay, I
participation.
get it. Sorry, I interrupted your.
We are talking of people's participation. Enhance it. We are talking of disciplining the decision-making power, processes. Then how do we really, ensure that? So if this is an opportunity to do that, we are doing it in a very, very,
half-hearted
that's
manner.
Right.
It's time for us to head into a break. When we return, we will show you an interview with Mr. R. Sridhar, Chairman, Mines, Minerals and People. Welcome back. My colleague Rajkamal Rao spoke to Chairman Mines, Minerals and People, R. Sridhar, and tried to get his point of view.
The Green Tribunal's judgments pointed out a lot of problems in the way public hearing process is conducted by the private authorities. You have been on the field. What kind of problems that are existing in the public hearing process?
In a sense, the public hearing was, I would say, both for the government and definitely for the corporates. It was something like an external burden that was being imposed upon them. Otherwise, they were, doing the way they wanted to mine. And when you see the huge outnumbering of illegal mines in India, right? In the parliament, they said 82,000 illegal mines as against 10,000 legal mines, right? So it has been seen not as a real process of incorporating those grievances, but okay, we have also heard you.
If you have to make a comment on the way NGT is working, what do you have to say? Are you satisfied with the way the NGT is working, or do you think it needs some more teeth to be improved on this part?
When the Green Tribunal was being formed, there were various kinds of things that, as usual, Mr. Jairam Ramesh had been proposing in different forums. So what actually happened was, like we had presented, several groups had presented what are the kinds that need to be there. And being able to raise an issue suo moto was one. But also we have been always cautioning that, is this whole tribunalizing of India and its justice actually pushing people farther from places where they can seek justice. For instance, if you make it a cognizable offence under some CRPC, any pollution, perhaps the guy can go to the local SDM court, right? But you ask him to come from Bellampalli to like Delhi or a bench when it sits somewhere close by. So are we, because if you see the land bill, it wants a tribunal. Environment, it wants a tribunal. Now tribals, they already have a commissioner. Now they will also want a tribunal. So we might end up pushing people into this thing, and then it can't settle. Ultimately, it is not the be all and end all of the justice in that kind of way.
Has the tribunal been able to take over even partly the role of the environment bench of the Supreme Court? My question to you, Mr. Vasudev, is first on the powers, quickly, on the powers of the Green Tribunal. Are we anywhere close to seeing an effective Green Tribunal?
No.
Second, IFS officers, the way they are supposed to be the officers, nodal agency, to man the environment and forest issues.
I'll answer it in very
Yeah.
brief. The tribunal has a maximum of 20 expert members, 20 members otherwise, and 1 chairman. The sitting of the tribunal is 1:1, that is 1 chairman and 1 member under the rules. You have a power to create state circuit benches which can go and sit. But the chairman can also call for a larger bench. Please keep this at the back of your mind. When he is going to select his sittings, it is going to be a matter of his discretion. It is not necessary that an expert would be with him all the time. Now, stage 2. The experts who are appointed are persons who are supposed to have certain specified qualifications, degrees and educational qualifications. The others who come in from the services, or the other members, do not include mandatorily a person who is concerned with the forest. For example, you have an Indian Forest Service. Who knows the forest better than members of the Indian Forest Service? They might be the service number 14 or 15 in the allied services, but they are a service by itself, like you have an income tax service, a revenue service. Why shouldn't those officers be brought in specifically into the Environment Ministry? It is just because some high-ranking bureaucrat wanting to continue his chief minister or secretaryship wants to retain the post, keeping the other services out. 3, if you're going to have an expert body, you must have experts on it. You cannot single out a system to say that we will do it, to the exclusion of those who know their business. This is exactly what is happening to the tribunal.
Tribal, yes, tribal point.
Now, fourth and the last. In our constitutional scheme, you have a sixth schedule and you have a backward area which defines what are specified areas. Most forests in the earlier times used to come under the six schedules. That is to say, tribal people. They had the rights of management, the Khasis, the Garos, the Karbi Anglongs. They have a very powerful right. Nagaland became a state, so it went out of this. The fact is, Northeast, they are the best managers of your forest. The people of Andaman Nicobars, they are the managers of their forests. They are being exploited. Why can't we ask the government to bring in these tribals whose existence is at stake to become members of these
The expert
tribunals?
committee.
Because they are the experts on forests. They might not be educated, but they have done it for thousands of years.
Yes.
Why exclude them?
On the participation of local people.
Well, I think we are going on a continuum. We are trying to look at, stitch all those things which probably need to be done.
Right.
And to make some sense to the Green Tribunal. And it lacks a lot of that, and it requires a lot of those stitches.
Yeah.
One thing is the powers of the tribunal. We notice it's certainly doesn't enjoy the
Up to
same
the mark.
status as the court,
Yeah.
Supreme Court. And then there are mismatch between the settlement powers of the tribunal in Section 14 and the appellate power of the tribunal. Sure. Then we notice also that the tribunal doesn't have the content power nor a very effective power of enforcing the decisions. So if that is, and then why do we therefore bring in a law which is again a shelterless law? The judges did not have a proper place to, even have the tribunal to function. So do we, therefore, do we have enact this kind of shelterless legislations? I mean, just using a phrase to convey so many things.
Yes, yes, yes.
So the Law Commission recommended primary benches and appellate benches.
Right.
The preamble talks about it. The appeal goes to the tribunal. To the Supreme Court from the tribunal. Look at from far-flung areas. Today, every economic activity of a substantive economic dimension will have an environmental dimension too.
Yes.
So every such issue, somebody may have a legal right or a constitutional right. Every such issue will have to travel to Delhi. And to borrow a well-known phrase of Justice Krishna Iyer, the Mughals in Delhi will sit in the Green Tribunal and decide all these issues. So therefore, the problem of
there are
access to justice.
too many hurdles to people's participation in the process of national
access to
consultation,
justice,
including public consultation. Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.